Good morning. We'll just get started in about 30 seconds, just waiting for a few more people to join us. Still waiting for quite a few people here. So while we're waiting, I'll just say a quick hello before we get started. So welcome to this morning's session. My name's Kyle and I work for Invest Ottawa, Ottawa's lead economic development agency here in the city. So I will be on the call today, helping to facilitate everything. We will be sending a follow-up email to everyone. So that will include access to today's recording that you'll have access to for 48 hours, the slide deck, as well as a feedback survey. So we do really appreciate your feedback, and we do share your feedback with our presenters as well. I'm still kind of curious why we don't have a few more people. So I'm a bit hesitant to get started, but I guess we could send them the recording if they missed the first couple minutes, just so we could respect everyone that showed up on time. So super happy to introduce, we have Lei from Smart and Biggar, Invest Ottawa's IP partner, who'll be talking about clean tech today. So Lei, did you want to take it away?
Yeah, sure. Thanks, Kyle. I think maybe we should wait just maybe an extra minute or two. Give people a chance to, well, I guess, yeah, maybe just a minute and see whether more people will get a chance to join.
Maybe people are, I always say that people are probably running late in another meeting or something or other. So,
yeah. Okay, so, all right, welcome everyone. I'll start. We'll do a brief introduction of myself and the firm anyway. So welcome everyone to this workshop. I think this is my second goal with a virtual workshop. It's not the ideal format. I very much rather meeting everyone in person at Invest Ottawa. But I guess that's still not an option. It has some benefits. Be able to join sessions like this remotely, but hopefully in the not too distant future, we'll be able to all meet in person, having live discussions about IP. Can everybody see my screen? I think now just should be the title slide. We're gonna talk about, okay. So we're gonna talk about IP and with a focus on climate tech. I think for people that, for innovators in this field, it's clean tech or climate tech. There might be, I think, the general trend of moving away from the term clean tech, but it's really one and the same thing, I think. So I'm going to try to stick to climate tech because I've been told a few times this is a more appropriate term. We'll move on to the next slide. A quick introduction of Smart and Biggar. We are the leading IP law firm in Canada. You can see on this little map here, we have 5 offices. Myself, I'm based in Ottawa, and for the last 18 months been based at home, and may continually doing so as well. We offer, I think you can see the 3 bullet points here. I think we offer our strengths reside in the complete suite of services that we offer that related to IP. So we'll start with protecting IP, procurement, and we have a strong litigation team, as well as a IP transaction team. But we only do provide legal services that related to intellectual property. We often work with business law firms if there is a transaction happens, either involving our clients. I think another strength of Smart Biggar that I think, especially for like I'm particularly proud of, is our deep technological expertise. So we have about 100 professionals at Smart Biggar, and then I think about 80% at the ballpark of us have advanced degrees in life science or engineering. So last time I counted, we have 18 PhDs that have different technical training across a wide spectrum of fields. And then, of course, I think a large number of professional engineers as well. So we file, I think, a significant number of patent trademarks in Canada. So this is who we are. So we, what we do is providing IP services. The objective of the services we provide will be to help you, our clients, to generate business value. I think everyone probably have heard about IP strategy, patent strategy, quite often. I think many companies and many innovators are getting more familiar with some of the basic concepts of IP and in many instances, in particular about patent. So I think there are many ways that IP can contribute to your business value. There's a few examples here in the slide, and then we'll get to some more concrete discussions later on. So for the presentation today, I'll break my talk into 4 sections. I will start with a brief introduction of intellectual property with a heavy focus on patent, because that's what I do. I'm a patent agent partner at Smart Biggar. Sorry, I think I forgot to give a quick introduction of myself. So I'm a partner patent agent at Smart Biggar. So I've been working at Smart Biggar for over 10 years. I think this is my 11th year. I have a PhD in biochemistry. So my practice, especially at the start of my career, has been heavily focused on pharmaceutical biotech companies. And in the last 3 years, I think I started with one client, stumbled upon one innovator in the clean tech, climate tech realm. And I think just I feel strongly about this specific topic, and at the personal level. And I also see, as I started following the field, I really started seeing a tremendous amount of growth of interest and investment. I think 2021, I think both 2020, even with the pandemic, and then continue on to 2021, I think we're seeing some historical number of investments, commitment in climate tech. And of course, I think especially in 2021, we have really some events that are happening that probably touched many people's personal lives. I think made more people from both innovators and investors to be more aware of the, I think really the significant moment we are at. And then I think from what I have been learning and reading, like this is a time we need to do something, and then to be able to protect our future, our our kids' future. I think we really need a strong innovation in every industry. I think that's why the climate tech, I guess there's a little bit of that behind the renaming from clean tech to climate tech. I think the clean tech was when it started in the late 2000, early 2010s, it was a strong focus on energy, biofuel in particular. But now climate tech has really covers pretty much everything we do on both industrial levels and then just consumer goods levels, and then the car we drive, the food we eat, and then they were all already seeing a I think significant growth of the climate tech element, and I think we will continue seeing that to pick up in the next decade. So I have, so in the last 3 years, I started trying to build my practice in the climate tech realm. But with my background, most my clients are doing chemistry or biotech innovations. So I will most of the content should generally apply to different disciplines, but you will see, I think I have some case studies. Most of my case studies are based on my personal experience, and then they all have a chemistry or biotech element in there. If you are in software business, then I think most of the contents will still apply, but I just want to let everyone know my background. So as I said, I'll start with introduction of IP with a focus on patent, and then I think the second part is one question that I'm encountered the most is when should we start consider patent protection? So we'll dive straight in that topic. And section 3, I'll talk about the differences between patent trade secrets, and then whether I think most clients I worked with could really benefit with a comprehensive review or diligence of its IP, and to decide what proportion of its IP should be protected by patent and what proportion should be protected by trade secrets. So I'm going to talk about that as well. And the last section is IP ownership, which is I think often neglected, but could be one of the most significant factors come down to transaction. So so this is the outline of what I'm going to talk about today. I'll start with the introduction of intellectual property. So I think one very important number I always kind of start when I talk about IP is the percentage of intangible assets. So as today, intangible assets are estimated to account for over 80% of S&P 500 market value, so 80%. And then that's compared to 17% in 1975. So I'm not an economist, but I have really been enjoying reading The Economist and listening to his podcast. I think there's some just fascinating article talking about the shift from tangible assets to intangible assets, what that means for businesses, and then the consequences, and then what business should consider and prepare for the future. So as the intangible assets, the percentage of intangible assets has grown and then may grow even further, I think that's bring the IP rights to the front and center. I think I really like this summary of IP rights. I think given the concept intangible, tangible, right? So IP rights are a way of capturing intangible assets into something that is concrete, enforceable, and usable to create tangible value. there are many types of IP rights. I already mentioned, I think the focus of today is patent, and then I'm going to talk about patent in combination with trade secret. But here, there are, generally speaking, there's 4 types of registerable IP rights. Trademark. So if you're a company that, if you're like if you're Lululemon, a trademark will be very important because that protects your brands and the good service that you offer. And trademark is perpetual, potentially, as long as it's maintained and all the fees are paid, and then the goods and service protected under the trademarks continue. The second type will be patent. So that protect how something works. And patent, generally speaking, has a 20-year term from the filing date of a patent application. I think at this, so I say generally 20 years because in many jurisdictions, there may be the possibility of term extension. And the mechanism of that can be quite complicated. And then also the 20 years also assuming that you're maintaining your patent application, paying all the necessary fees as well. And then the third type is industrial design. So I think it goes together with patent, but patent protects how, and then the industrial designs protect how it looks, how it works, and then industrial design protects how it works. And then it's I think some good example would be the iPhone, the interface with the different icons. That's an example of industrial design. It has limited use because it does not protect how it works. So it really just protects a specific design. And then because it may be circumvented relatively easily. So as I said, it's sometimes, I think more often used as a supplement to patent, but I think it's not a dominating way of protecting innovation. And it also has a term. So generally speaking, 15 years in filing. And then there's copyright, so protects original creative works. And then it could be more than 50 years or longer. So I think for today's topic, as I mentioned, we're going to focus on patent because for most innovators in climate tech realm, that it will be together with trade secrets will form the majority of your IP rights. There will be trademarks, maybe there's some industrial designs, but it would not be the it shouldn't be the dominating form. But there's always going to be exceptions, but and then trademark, industrial design, copyright. Really, we need different experts in different fields to dive into the specific topics. And then I'll just focus on patent. This is what I do day to day. So as I said, I will jump into patents. Instead of giving people a 101 of patents, I think from my experience working with innovators, especially startups, I think it's more important, like you engage a patent agent, a patent lawyer to protect your invention. It's our job to come up with ways to best protect your invention, working with you. So I'm going to skip the 101 part, but rather we'll start with talking about some myths about patents that I heard and my colleagues also have encountered, and then just generally people have some misconceptions about patents. So I'll start with this, and then I think starting from this slide, please feel free to put your question in Q&A. Kyle will remind me, or if I get a second, I can look at the Q&A myself as well. Try to make this more interactive, because I think the next couple of slides, I'm going to try to. It's not a tutorial about what the patent requirements are, but more about how I think generally what questions I received from the even from the management, from the CEOs, from the CTOs, just about the general but more strategic questions about patents. So the first one, if I get a patent on my invention, then I can commercialize it without worrying about the patents of others. That is incorrect. Patent is a exclusive legal rights. Getting a patent does not permit you to practice what is patented. It only allows you to prevent others from doing what is patented. So you could obtain a patent based on a existing product. If you made improvements to an existing product, if it's possible, you could obtain a patent protection for the improvement. But there could be patent rights attached to the product, and that patent right could have a broad scope that could cover your improvement, although your improvement is novel and inventive and it's not disclosed in the last gen IP. But that last gen IP could have claim broad enough that still, even with improvement, your Gen 2 product may still fall within the Gen 1 IP rights. And then, so getting a patent for that improvement or Gen 2 product, you may still at risk of infringing the Gen 1 IP. And this frankly happens quite all the time. And then because most products most innovations are incremental improvements on what is existing. So it's, as I said, it's exclusive right. So you may not be able to actually practice what you invented, but getting a patent means nobody else can practice what is invented without your permission. So that's, I think, one of the most important understanding of patent rights is to understand this exclusive nature. And then there could be layered IP rights on one product. And then like iPhone, I think was a very good example. I can't remember the exact number of patents, but I think could be easily in the hundreds of the, if not thousand range. Like one iPhone could have that many patents, each part, each element, each component. The second one is if you do not have the resources or are not willing to sue for patent infringement, there is no point in seeking patent protection. I hear that question quite a bit because everybody knows patent litigation or any form of litigation is extremely costly. And then startups, not even startups, even SMEs often, just as a matter of fact, are not at the position of starting a litigation suit, especially not bring an action all the way to court. I think in Canada, you're looking at $1 million to start. That's to like that probably not even that $1 million may just bring you to the court, and in the U.S. that could be 10 times that cost. But getting IP rights are very important because it have many uses beyond litigation. I think a few examples would include attracting more investors and enhancing your company valuation, and facilitating licensing and collaborations. The third, I think, misconception is you need to have a working prototype before you file for patent protection. So that is, again, not true. There's no requirement you need to build a working prototype. Different jurisdictions have different requirements on how much data or how much exemplification you need to provide in the patent application to satisfy their own patent law. But generally speaking, you need to describe your invention in enough detail to allow someone else to build it. So you don't need to actually do it, as long you provide sufficient description of your invention that is enabling for someone that in the same field, once they read your description and say, look, I can practice your invention. So this is, again, the general principle kind of once as how it applies to specific fields will be quite different, right? That you can imagine if you are working on a cancer drug, if you only describe what your compound is, and you say, look, my compound can treat a specific or many forms of cancers, that just wouldn't work, because that's such a specific field that looking at the chemical structure, really you cannot predict therapeutic efficacy. And then you really can't say, look, I have this magic bullet that can treat a specific disease without any proof. But on some other more mechanical inventions, if you are talking about specific arrangement of existing products or something that everybody knows how to build, and then you just don't have the investment to actually build a prototype, large machinery, or sometimes even a facility, then I think as long as what you describe makes sense to people in your field, then the written description alone without any working prototype may be sufficient. So it's not black or white. I say no working prototype is required. That means it's not necessary, but I think for certain fields, you will need to present some necessary data, where for others, you don't need to. And then I think I just want to, as I said, I'm not a, I don't do software patents, but I just want to bring this up here. I think is again, it's a very frequent question that me and my colleagues encounter, is that software is not patentable. That is not entirely correct. So processes, GUIs, and other computer implement solution can be protected. The code per se will be protected by copyright. So this one is not. It's kind of, yeah. So it's has some. You really want to work with people, do software patenting. Many software companies do pursue patent protections, but it's not straightforward because you can't patent the code. And at a high level, I think we talk about so hopefully by going through some of the misconceptions about patent, I cover some of the basics about patenting. And then this slide, I want to talk about patent strategy or IP strategy at a relatively high level, just so I think everyone has an idea of what IP strategy or patent strategy may entail, because sometimes I think many people may think, well, why do you need a strategy, right? Because if I invented something from my R&D and then it's new, if my engineers or my scientists in the lab told me that this is new and then this is inventive, then I should protect it by filing a patent. So why do we need a strategy? It's more about, look, do I have enough funding to protect all the R&D, all the inventions that come downstream R&D activities? I think that is one way to operate. I think you can see in the first category here. I think we gave a term called operational patenting. So you will only protect what you come up in your innovation pipeline. And so under this stream, generally speaking, the internal or external IP councils will just interact with engineers and scientists, because they're the one that think they have created something And then, as I said, either you in-house or external IP counsel will be engaged, and then to draft a patent application to protect that invention. Under this stream, generally speaking, the IP counsels do not interact with other segments of your business. And then one issue with this operational stream is really the what we see very often. They will result in a the IP created under the stream may not align with business objectives, because the IP protection was simply dictated by your R&D department, and which may not work without any marketing insight, and then also it's more often than not purely dictated by budget. And then so on the flip side, from the operational stream, there is, I think, it's just different way of thinking, different way of protecting IP. So we call it the predictive or forward-looking way of patenting. And then, so under this stream, we are trying to, the question we're asking is different, as you can see, right? So under operational stream, we're asking, look, what have we invented? Under the predictive stream, the question we're asking is, look, what technology will be needed in the market in the future? So here, an innovator will import more business insights. So not just technical insights, but also combine the technical insights with business insights, and then combine both at the very beginning of IP creation, thinking, look, we'll be able to protect the future, and then make sure the patents we file have value, that we can actually generate return from the IP, from the patents that we spend a lot of money, and then we want to see a tangible return on those IP. And then the last stream is a targeted approach. So this is, the targeted approach could be combined with both operational or predictive stream. For the targeted approach, we're really talking about at a specific moment, if you have a specific opportunity such as licensing, litigation, or valuation, and then how can we shape the IP to bring value for that specific opportunity. The targeted stream goes really well with predictive forward-looking stream, because for both predictive and targeted stream, what we're really trying to do is to make sure the IP generated brings value, instead of just passively protecting inventions that sometimes may be taken out of the context of your business objectives. So that's the first section, which is, as I said, I didn't want to give a patent 101, which I think many of you might already heard about. And then, frankly, it's our job, right, to make sure all the requirements are met. So hopefully the first session, at a high level, give you guys some idea of the different ways or different philosophies of patent strategy. And then section 2, I think I'll dive in here, is I mentioned at the introduction part, this is one of the questions I probably encountered the most, is when. I think this is really the million-dollar question. Given there are many just intrinsic properties of patents make the timing of filing a patent so important. So this is a legal document. Once a patent application is filed, you cannot go back, modify, add, or delete content. And then, as I mentioned, it has a 20-year term. or longer. So for certain industries, having patent, that's really the most important way to ensure market exclusivity. And then so you have to really have a good foresight of the future to make sure your protection is robust enough. So I think the timing, as I said, is there's really no one size fits all answer here. It's not like okay we want to file as early as possible, or we want to file when we have enough data, have enough funding. You don't want to take I think most times you don't want to take the most aggressive approach, and you also don't want to just sit and wait. So filing early, there are a number of issues associated with a too early filing. So I think I have 3 here. So first, when you file too early, you may not fully appreciate the scope of your invention. That means you may not know how broad your IP protection need to be. You may only realize one way of one embodiment or 2 embodiments without the chance to consider or test variables. So you wouldn't know how broadly your invention covers. So that is quite important, because without protecting the necessary scope, you're leaving room for your competitors, any third parties, to essentially take advantage of your invention. Because they can, as I mentioned, they could once someone sees your invention, they may start asking questions. Look, can we change one component with another? Can we eliminate or add more components, and making improvements in one way or another? And then they may be able to obtain patent protection. You cannot prevent people making improvements, but you could make sure you have a broad scope. That, as I explained earlier, that broad scope can actually prevent someone else to practice their own improvements. And then a very popular issue is at early stage, there's just not enough data. You may have some ideas, you may have some proof of concept data, but it's just not enough to support that scope. Like even look, I need this scope, because you may have some market intelligence. You realize, look, I have only tested this one specific material, but I think it will work with all the different materials within certain genus, and then but you just simply don't have the time or resources to test. And then not having enough data may make it quite difficult to get that desirable scope. And the third issue is actually sometimes it's hard to predict. Nobody have this crystal ball, but the third one is actually sometimes may have the most significant consequence. Is once you file an application, it will be published. So generally speaking, you will file a US provisional application, using that as an example, and then you have to file a formal application in the form as a US, Canadian, or PCT application within a year from the filing date of the provisional application. And that formal application will be published 18 months from the provisional filing date. So you cannot stop that. I think there's some very, very limited circumstances you could request the patent office to keep your application unpublished, but I think generally that relates to military, defense, national secrets, stuff like that. Probably wouldn't apply to climate tech. So if you file an application, you will be published, and that publication actually may block a later more valuable application. So you have, as I said, you may have some basic ideas, some basic data, and maybe just by sheer, most time because you just don't have enough time, or again, you don't have enough funding to test different things. And then 3 years later, you may have attracted enough investment, and then which enable you to test many different things to actually validate some of your early theories. And then that application could be a lot robust because of data and because your clear understanding of the valid scope of invention, which means that application, the later application, will be more important for you to assert against potential infringers and then to license, for example. But then that later application may get blocked because of your early application. So that's something that it's difficult. As I said, it's difficult to predict the future, but it's actually a very, very important consideration is, would I block myself? On the flip side, patent filing is a race. Is in majority of the jurisdictions now, and then in all the important jurisdictions that most companies that are considering North America, that's Canada, US, Europe, the entire Europe, and then Japan, China, the patent protection is, the patent rights are granted on the first to file basis. So if two people have invented the same thing separately, then the person or the entity that files the patent first will get the rights. And then if you're late, then you're out of luck. But then that is a rare circumstance, like two people invent exactly the same thing. That doesn't happen a lot. Most times what happens is, as you're trying to develop or try to develop your invention, generate more data, is in that time frame, people will be working on things in the same field. They're not working on your invention. As I said, it's rare that two entities come up with exactly the same thing, but then there'll be your competitors or just third parties that are working in the same field, and then they will continue to file applications or publish academic journal, peer-reviewed articles. So you will get more and more relevant art in the field as you sit and wait and develop. There are going to be more and more data coming out, more and more knowledge start filling in that field, which means you're going to make it easier for the patent office to assemble those knowledge, those prior art for obvious attack when you try to get a patent. So the longer you sit, the more knowledge going to be generated in that field, and then that just gives the patent office more ammunitions to form attack. And then another issue for filing too late is, as you're waiting, there's always chance of non-confidential disclosure. Sometimes unintentional, sometimes just, as I said, it happens not all the time, but then depending on the company size, I think once your company grows to a certain size, you will realize it's accidental disclosure will become sometimes become a pretty serious threat, because your researcher, your engineers may go to a conference, and then even though they did not mean to disclose, but then as the conversation goes, they start talking about what they've been working on, and then in a non-confidential environment, and then that all could jeopardize your IP rights down the road. So as you see, this is really a I think most of the times my recommendation to my clients is always to consider everything, and then try to find that balance. You can make the most informed decision. I think that's the best you can do, is make the most informed decision. I don't want to use the word gamble, but it is a little bit of gamble no matter what you do, because there's no way to know. You can predict and you can plan and predict as much as you can, but I think, as we all know, innovation does not happen in a linear fashion, and then it's really hard to predict what may what you or someone else may invent, innovate in the next year, not let alone the next 3 to 5 years. So I think I will, in this slide, I'm going to provide a few considerations, give you some more concrete examples on what considerations, so you understand the pros and cons of filing early and filing late. And then, so what are some of the considerations that you should go through as you're making that decision? Sometimes could be one of the most significant decisions you have to make, especially the early stage for a company. So I think one thing is market intelligence, because a lot of the guessing game will be based on how much you know about your competitors, other companies in the same field, what they are doing. The more you know, I think the more guidance you will have. I have clients that's very confident about what they're doing is unique. Nobody can be 100% certain, but they're 90% certain that they are working on something so unique that nobody else, no competitor is working on. And then I also have clients who have a good grasp on how close their competitors are catching up. So which may actually means translate into greater degree of urgency in filing. So one practical tip here is that a freedom to operate search or IP landscape analysis. Sometimes the FTO analysis, I think generally speaking, sometimes FTO analysis may become necessary even at the very early stage of tracking investment. I think what I see is investors are getting more and more sophisticated in IP, and FTO is they ask FTO at a very early stage. Like if I invest in your company, do you have freedom to operate? And then so sometimes you do FTO for that specific purpose, but the information coming out from that analysis could be very valuable in guiding your own patent decisions. Because through FTO analysis, you should be able to see a pretty good snapshot of everything going on in the related, like in companies, and then work on the related technologies. And then with that information, as I said, will give you a good idea as where you're at relative to people in the same field. And the second consideration is your R&D capabilities. So how fast can proof of concept results be generated? I already mentioned about this 1-year time window between the first provisional filing and then the formalization deadline. So you file a US provisional application, and then I think most times the formalization application will be a PCT application. And then so you have this 1-year window that may be relied upon to add data. And then I think how much data you can generate within that 1 year also play an important role in guiding your timing decision. If you're confident, look, I just need to get the broad concept protected with a provisional application, and then I can fill in the data within a year, then may enable you to file earlier than needed, because you don't need to wait for the data to come out. Look, this data will come out in that 1-year window. And the last one is disclosure risks. I already mentioned. The longer you wait, then there are just more chances of disclosure. I think I just give you a couple examples. Actually, other than someone intentionally reveal the secret, I think more often you will run into problems like press release. You had to do a press release, and then grant application. If you try to get either if you're working with academic partner or you want to apply for government grant, and then there's collaboration opportunities coming up. which all going to force you to disclose. I think the rule of thumb is always try to disclose try to file before any disclosure, even you think the disclosure will be under NDA, non-disclosure agreement, because it's just better to get to flag, to plan that, to secure that filing date. It's just so important for patentability and ownership. You could rely on NDA, but then it's really depending on the good faith, whether the third party is acting on good faith. If you are negotiating with multinationals, you know the means they have is going to be triumph yours by different scales. And then if the party that you're negotiating with act in bad faith, yes, you may be able to hold them accountable in court, but then the damage may be irreversible. So my general recommendation is always file before any disclosure, regardless of the agreements, whether agreements will be in place or not. I think you should have agreements. I'm not saying you shouldn't have agreements. You should have agreements. You always should ask for NDA before disclosure. But I just wouldn't rely on NDA alone to secure my secure my IP rights. And in this slide, we were touched, I think, just in my earlier slides. I already touched upon the point of data a couple of times. I think, again, this is more depending on the amount of data required is really a differ depending on the specific field you're in. I think on one end of the spectrum, you're probably looking at therapeutic inventions where you claim you have invented something that can treat a disease that may have the highest threshold for data. On the other hand, if you are having a simple mechanical invention like pencil sharpener or certain mechanical things, then it may have the lowest threshold because everybody will, and once you draw a blueprint, everybody will understand how the thing works and will anticipate it will work. So for climate tech, I think depending which specific category of climate tech you fit in, I think it will be different thresholds of requirement for data in the application. So I think this is similar to the myths, debunking the myth. So I'm going to talk about a few things that maybe, again, maybe considered like misconceptions. So what is not required? You do not need to prove scalability. You do not need to prove, look, I can practice my invention at industrial scale. So you have a prototype, you don't need to show, look, you can manufacture this at large scale. And even for therapeutic inventions, you do not need to show actually it complies with regulations. So as I said, even for inventions with highest threshold for data, you do not need to show did it actually, it passed the clinical trial. There's no way anyone can wait that long to file a patent application. And then you do not need to show it works better than competitors' products. I think it's often important in your marketing material, in your pitch deck, that look, what I'm inventing is better than competitors' products in some way. It can be very helpful, but it's not required. So what is desirable? I think there's 3 points that goes kind of on the minimally, you will need proof of concept data. So again, mechanical invention, you may not even need proof of concept data, but for energy invention, if you're working in hydrogen, if you're working in energy storage, if you're working at carbon capture, I think you will require some proof of concept data instead of just a description of what you invented. So I think that's the minimum threshold. And then if you can provide more data, the next thing to think about is whether you can demonstrate unexpected advantages. So give you an example, if you have an invention, if there is existing product, and then you replace one component with a a next-gen component that's, again, existing in the market. So you have a component, and then someone else invented a better version of that specific component, and then you replace the old component with the new component, and then the expectation is it will work better because that's what was known. So that will be expected, which is, generally speaking, the patent office will attack you for obviousness because the improvement that you generated is expected. Where you really want to have is something that is unexpected. For example, synergy is a very good example. Like 1 + 1 works better than 2. You have two things do the same, have the same function, but if you combine them together, you generate synergy. That is one of the most kind of frequent used demonstration of unexpected advantage. And then ultimately, you want to generate enough data to supporting the broad scope. So I think this goes 3 levels. You want to make sure you have data to show your invention indeed works. And then if you can, then you want to generate data shows, well, it worked in an unexpected manner. And last, if resources permit, you want to generate data testing different iterations of your invention so that can support a very broad scope. So when I work with my clients, I interact with their R&D and their business people at a very early stage. I don't take the R&D inventions as is, like wait for the R&D generate some invention. Generally, when I work with my clients, I get in very early. I try to understand where they're going, what they try to develop in their labs. And then once we decide, look, we have something minimum that can support patent, and then we want to I will help them design experimentations, because we want to to obtain a patent, you want to tell a story. Why my patent, why my invention is inventive. And then so you want to build this inventive story with the scientists, with the engineers, and then design experimentations for that specific purpose. And then because sometimes the R&D experimentation may not fully illustrate or support what is truly inventive about your invention. And another approach that I often take is try to work with the lab is to try to find some low cost, more high throughput test, like something very simple, but it can generate a lot of data in a very short period of time. Because generally in R&D, you may do a screening at the beginning, and then once you find your candidates, you're going to run through some more advanced testings to make sure it has all you meet the requirements to bring to the market. And then so once you go through the initial screening, you may focus on 2 or 3 candidates, and then run those 2 to 3 candidates through like more and more advanced testing, like different scale, like to show that it actually can scale up. But as I said, now those is really required for patenting. And to support broad scope, sometimes it's more important to test different iterations, different variables, different materials. And then you don't need to generate data. You don't need to show what each iteration works the same. They all work as well as a candidate. No, you just need to show the different iterations have the minimum utility, so it works. It may not work as well as your candidate, but you have a large pool of data showing, look, by changing a specific component using different alternatives of that specific component, my invention still works. Yes, it may not work as well, like you will see some differences in performance, but they all work. It meets the minimum requirements. Those data can be very, very, very useful when you try to obtain that broad scope. You don't need a regulatory compliance or stability data, and then because those data generally will be generated just for your leading compound, your leading candidate, and then those data actually generally speaking don't really have much use in helping you to secure the desirable claim scope. Rather, it's those low cost, very simple tests you can do, and then they can generate a lot of data. And then, so at a very low cost. And then if you have those data in the application, you'll really facilitate the patent procurement down the road. So I'll give a case study here. Just to illustrate some of the points I explained. This case study is more about timing and data, right? So combine both data and timing. To give you an example, so ABC Tech has developed a technology to produce X with less energy consumption. So they have developed this process to produce something with less energy. And they've been working on this for a while. And then they realize, well, even though we started on that road with market intelligence, with their business acumen, they think, well, the market really reside in X prime. It's similar to X, but it's different. And they're confident that, look, my technology will work with X prime as well. So a brief landscape analysis with us revealed there very little IP on the production of X prime. So it's pretty open field. What we decided to do is file provisional application right away without data. But experimentations were designed to generate minimum data required for patentability within a year. So we made a decision, we discussed with the scientists. We have a fair degree of confidence that the existing technology will work for a different purpose. We just don't have data, we haven't tested anything, but we're confident, look, the experimentation can be done within a year. So we filed a provisional application. And then as expected, data was generated within that 1 year window. And then now ABC Tech has a significant competitive advantage in the field because there's very little IP on the production of X prime. So this is, I think, example like illustrating about the timing, the consideration that come into play to decide the timing, and then how you're going to bring in the data consideration in this timing consideration as well. Okay, so I think the second part take quite a bit of time. For sections 3 and 4, I will go through them relatively faster, so we can wrap up all the content in the next 20 minutes or so. For patent trade secrets, so trade secret is any confidential business information that provides a competitive edge. I have the picture of the KFC there together with Coca-Cola. I think there's a number of famous recipes that are trade secrets, and the Google algorithms, search algorithms are trade secrets. But trade secret is actually really quite broad. It covers methods, formulas, recipes, even a supplier list is trade secret, and data. It does not rely on government granted rights. That's why it wasn't included in that 4 categories of IP rights at the beginning. There are different country, even within the same country, say within the US, different states have different law about trade secrets. To protect trade secrets, I think as we all know about Coca-Cola, KFC, it has the potential to be perpetual monopoly, but you need to take concrete steps to keep it secret. And then one of the so at this for this consideration, the most important thing is access to information, right? Used to be maybe back 20, 30 years ago, it's just really physical access, but now there's the virtual access to information as well. So I identified a few examples that you need to, like a company, to consider if we want to maintain trade secret. It is really it can get quite complicated especially as the business grows, as you bring in new employees or the existing employee leave. It involves other areas of law as well, especially employment law, because your employment contract could be crucial in protecting your trade secrets. I think as I mentioned, I think optimum IP protection can only be achieved by pursuing both patent protection and trade secret protection. I think there rarely a case where you want to reveal all your secrets. You want to obtain some patent protection while maintaining a certain percentage of your IP as trade secrets. I think there are a couple considerations as you go through that exercise in deciding, look, should I patent or should I keep that secret? So useful life. The trade secret, as I said, it could be perpetual. And then often the reason you want to keep something trade secret is you think the patent term is not enough, right? The 20-year term is not long enough. So you want to have protection over that 20-year term. So unless something's useful for over the patent term, then it may not be necessary to protect that trade secret. Reverse engineering is really important. Once your product goes on the market, whether people can figure out how it works. If something can be reverse engineered, it almost means you cannot keep trade secrets, and vice versa. And then one thing about pursuing patent protection, as I said, there are different purposes of patent protection, but the one important consideration is whether you can detect infringement. So if you don't think you can detect infringement, that may push you towards trade secret protection. And then licensing and sale opportunities, generally it'll be easier to license a patent rights. You could combine trade secrets as part of the licensing deal as well, but you probably, like generally speaking, a significant portion of licensing will be like registrable patent IP rights, such as trademark and patents. And another thing about patenting is, I think it could be actually really relevant in the climate tech field, because many innovators had to work with a existing supply chain. Like your product had to fix a specific provide a specific solution in the very complex supply chain. So you want to think about, look, whether I can control the supply chain via patenting. Another case study here. I think this is this is not my client. I have heard about their IP strategy, which I think is one of the most well thought and then very well balanced IP strategy for patent and trade secrets. So this company developed a technology to recycle metal Y. So you can see this is a very climate tech company. It has patented processes for recycling metal Y. So the steps need to be done to recycle the metal from the raw material. And the big reason is the processes are carried out in stations across like North America. It is nearly impossible to maintain the process as trade secrets. They have to sometimes they have to work with local governments, they have to work with different raw material suppliers. And then sometimes the people operating the process is actually not their employees. So it really just rendered it theoretically impossible to keep it secrets. But nevertheless, the company had developed a very smart, I think, intelligent way of supplementing patent protection with trade secret. So they have the chemical. So for each step along the process, you had to add chemical solutions, and then they maintain most of the formulas used for each step of the process as trade secrets, because they consider, like, the formulas are very difficult to be reverse engineered. Even someone can obtain a sample of the solution, but it's very difficult to reverse engineer and to come up with the exact recipe list. And then they don't, as I said, the recycling itself is carried out across North America, but the manufacture of the chemical solutions are strictly controlled by the company. So they will manufacture the solutions and ship it to the different stations. So employees at each station will know, they were trained to know when and how much each solution is to be added without knowing what are in each formula. So in this way, by combining both patent protection and trade secrets, I think they really build a very robust protection. So even when the patent process expire, it's going to be very difficult for their competitors to catch up with them, because they still have to develop those chemical solutions on their own. And then where the chemical solution, and then on the flip side, if the chemical solutions, the identities of the chemical solutions had to be revealed intentionally or unintentionally, they still have the patent protection. They still have that layer of patent protection of the process. And again, will be able to enable market exclusivity for the innovator. And as I said, as I mentioned, this is this specific company. I learned about their IP strategy and was very impressed by what they designed. But by listening to their IP strategy, as I was sitting there, I thought, look, there may be some other opportunities for patenting. And then I just give it here. As I said, like you can see on the slide, I said it's hypothetical. I just want to give you some ideas of what on that concept of protecting, control the supply chain, what that means, right? So the metal Y is a known metal, so you can't patent something that's known. But what about the intermediates, right? It's a multi-step process, and then along each step, they're going to be intermediate. Would there be any novel intermediates? I don't know. As I said, this is just my personal thoughts when I was listening to their presentation. And I think, especially if the intermediates will be shipped from one station to another station, it may be very valuable to patent the intermediates, because then you can really control that shipping part of the supply chain, right? If one station only process the first two steps, and they'll ship the intermediate to the next station because they have the better equipment to finish the processing. I think if you can capture that intermediate that be shipped, it'll be very, very valuable. And then another thought is the product recovered at the end is a mixture of metal Y and other components. You never get 100% purity. Another way to protect your IP is, yes, even by acknowledging you can't protect metal Y, maybe you can protect a mixture with a defined degree of impurities. You say less than 0.2% impurities. And then it is possible to actually protect that mixture. So by protecting that mixture, that will give the company 123 a strong leverage in their downstream customers, right? Because they're going to recycle the metal Y, and then some like other companies in the ecosystem will purchase the recycled metal Y, and then put it back in the supply chain. If you can protect the mixture of the metal Y, again, that will really increase the value of the IP. The last topic is IP ownership. Generally, IP ownership is an issue comes up during IP due diligence, either during licensing or during transaction at M&A. That's when IP ownership issue comes up. It is difficult to solve if not addressed in a timely manner. You could be looking at inventors that have left the company years ago that you really have no means to track, and then in the time frame of a deal, you simply may just not have enough time, and then if it's not resolved, really can derail a significant investment or acquisition when IP asset is the key consideration there. The good news is, if you start thinking about IP ownership very early, along the way, along your company growth, simple measures early on can help avoid, mitigate significant problems later. Some basic, I think I was really just going to touch on this topic at a pretty basic level. So you need to remember, employees generally own inventions made during the employment unless there's express contract to the contrary. So as I mentioned, your employment agreement need to have IP provision, calling out who own the IP rights. And then contractors, the same thing. You need to make sure there's the contractors will own inventions unless there is express agreement to the contrary. And then when you engage in different relationships, there are different considerations for IP ownership. I'm not going to read all the bullet points. I think the slides will be shared. And then so if you want a copy, you can obtain one. And then it's one thing about IP ownership is, again, rarely you will have the same fact repeated. Generally speaking, each company has some very unique, especially startups, you'll always have some unique challenges come down to IP ownership. What I see now is from my own line of work is the more and more intertwine between startups and research institutions such as universities. And then because a lot of the startups are coming from university now, and the university have a growing interest in spinning out their research IP. And the IP owner rights, I think, with research institutions can get quite complicated. It also depends on the sophistication of the institution you're dealing with. Some institution has very well thought of IP agreement, some have none, and then it really varies quite a bit. But it is very important, I think, especially for spin-offs from the university, to consider whether they have a clear cut from the university and whether they actually own the IP rights they think they own. But the general recommendation here is to ensure you have fully executed copies of all agreements, signed and dated, and have the agreements reviewed by your IP counsel. We'll end the presentation with one last case study. And this case study just give you an example of the IP component is really everywhere. And then this is one of my clients. They were working with multinational V for a while, engaging them and then making pitches because they think their product can be adopted by V. And then we'll open the doors for them, open many more doors for them. So the partnership, as I said, negotiation had been ongoing for a while. Finally, company V scheduled field test of my client's product. And then before the field test, 2 days before the field test, my client received a standard consulting agreement. And then it has an IP section, right? And I just kind of give you an idea of what was in the original copy of the IP section that's sent by V. So consultant, so here will be my client, further agrees all inventions shall be the property of V. And consultants agree to assign hereby does assign all rights to said inventions to V. So if there's anything coming out from this field testing, the rights automatically be owned by V. And then that's not even the worst part. The worst part is actually, it's about confidential information. The party agreed that all information related to the results of testing under the services shall be considered V's confidential information. So this is a very broad and then ambiguous provision. So all information related to the results of testing. So my client has a very well-balanced IP protection using both patent and trade secrets. And then there's a lot of trade secrets tied to its product W. So when this broad term, all information related to the results of testing, it may be construed to cover actually confidential information that my client been working really hard to protect, that tied to their product W, right? So if this provision was now reviewed and now negotiated, and if you're signing this agreement, which is standard consulting agreement, if you look at the agreement, most of the 9 out of 10 sections are really standard. It is standard for field tests, but this IP section really has these two potential significant mines that if you don't negotiate, you don't revise, could put yourself, like in this case, my clients, at significant disadvantage in IP ownership. I'm not going to discuss how we address the issue, but I just want to let you know it was a win-win situation at the end. Both parties agreed to some very sensible provisions. But then I just want to show you, look, this has just come from they churn out this kind of agreements all the time. They have a template and they'll send to anybody they work with, and then by signing those agreements without the IP provision reviewed, I think there could be some pretty damaging consequences. So that's the end of my presentation. My colleague, I never heard about Online K because I don't work in the computer field, but my colleagues, they use this. My software EE engineer colleagues, they use this to end their presentation. I really liked it. I think it makes a lot of sense with what we're talking about here. Really take a more forward-thinking approach with your IP, and then create your future and then protect it at the same time. So thank you. We have a few minutes left. We're happy to answer any questions.
Well, thank you so much, Lei, for the session. And we will take a look at the Q&A. So Rafiq is asking, what is your contact information to keep in touch with you? Oh, perfect.
Yep,
it's right
here.
there. And as we wait for a few more questions, I'm sure some people are typing, so I don't want to just end it right now. But as a reminder, for those of you who joined us a few minutes late, you will receive a copy of this recording that you'll have, that you'll have access to for 48 hours after the session. So I will be sending a follow-up email to you all this afternoon. And I believe Lei will also be sharing his slides with me that I can circulate to you folks as well. As mentioned, we do have a feedback survey that will be in that follow-up email. So we do really appreciate any feedback. It is completely anonymous. So tell us what you would like to see, what areas you need help with, and it could also help us improve our service offering to Ottawa area entrepreneurs. Still not seeing any questions here. Oh, someone in the chat here. So how do you ensure that a lawyer you talk to will not file patent to his benefit?
Oh, well, engage a reputable firm. I personally am not aware of such incidents where, because anything, even when you approach a law firm, the information that you shared will be protected. We cannot, under no circumstance, we can disclose information that you reveal to us, even just on a informal consultation stage. So everything you tell a lawyer should be confidential, maintain confidential, and then that's just the requirement for us. I think, as I said, I'm not aware of such instance where someone like my peers in the field will take information and then for their own benefit. But then I think just be careful, right? Overall, you want to make sure the firm you talk to is reputable, and then be careful when engaging people, like don't have a website, or I think the patent office, the Canadian Patent Office, also has a list of registered patent agents. I think people on that list should be very very safe to talk to. So Kyle said, do lawyers sign NDA with potential client? No, we don't for the initial consultation. I generally do an initial consultation with if you come as a cold call. I generally do an initial consultation with a prospect client. We don't sign NDA there. Actually, I don't ask. I will specifically ask you not to reveal any confidential information, even though any information you revealed will be kept confidential. But we have a formal engagement process. Like my firm will require if you to become in order for someone to become our client, will require you to sign a formal engagement letter, and then in that engagement letter will specifically calls out the disclosure obligation, non-disclosure obligations for us, and then so you have peace of mind. You have that agreement in your hand, and then. But as I said, it's really not a. As I said, I haven't known any incidents, and as long as you engage a reputable firm and a registered patent agent, that shouldn't be an issue. But it's for your own protection. Yes, you should ask one. And we actually, as I said, we always ask for one for our own benefit as well. How does one value their patent in the marketplace? And also how to sell license patent. There are some, as you can understand, I think this is this intangible assets. It's hard to put dollar value. There are firms, and then within my firms, I have my colleagues who are more specialized in patent valuation. There's some known methods. I think one way is really to looking at your projected revenue, and then if you can show, look, this is my projected revenue, and then that revenue is because I have market exclusivity based on my patent, then that your sales value or your revenue could be tied to patent valuation. There are many ways of doing it, and they're actually specialized firms. They're not patent firms, they're specialized firms, evaluation firms as well. And then licensed patents is you need to have if you want to develop patents, you want to develop IP portfolio for licensing specifically, really requires a lot of market intelligence. You want to build, you want to know the market really, really well, and make sure that you have something the market wants, and you even want to make sure you have an idea of look, who are my potential buyers, licensees, right? And then you want to build your patent application with really good claims that will give you the leverage in that process. It's not a simple question, and then really requires, I think, the innovator and their IP counsel work hand in hand at the early stage, and then with that information in hand, and then you can working towards that goal, right? Okay, I've got 1 minute. I'll just answer this last question. General cost for patent. It's depend on the field, depending on the firm you engage. I think for Smart Biggar, for myself, if you have a chemical invention or biotech invention, generally we'll estimate 10,000 for us to draft a application. That's just draft the application, and then the patent process is really complicated. If you want to get a patent in Japan, Australia, China, each country you have to file a separate patent application, and then the cost of that is very difficult to predict. But generally speaking, I would just tell people that interested in to engage us for as I said, when I say chemical and biotech, because generally it may be a little bit more complicated than simple mechanical invention. So I would say 10,000 for us to be able to work with you and then prepare a application.
Well, fantastic. So we are now at 11:30, so we could wrap it up there. I just want to say a big thank you to Lei for all the information shared today. And a huge thank you to Invest Ottawa sponsor Smart and Bigger for putting on the session for everyone today. So before we close things off, do you have any closing remarks, Lei?
Oh, no, thanks for everyone listening in. And then you have my contact information. Please feel free to shoot me an email if you want to, you think we may be able to work together.
Perfect. All right. Well, hope everyone enjoys the remainder of your day, and take care, everyone.